right, the court will call the matter, case number 22FY0827, the State of Michigan versus Christopher Schur. If we could have appearances for the record.
Mark Dodge on behalf of Officer Schur.
Matt Pagula, behalf of Officer Schur.
Kelly Hamilton on behalf of Officer Schur.
David Dodge on behalf of Officer Schur.
All right, good afternoon, everyone. Good afternoon, Mr. Schur.
Good afternoon.
All right, you can hear everything okay? Your counsel are here physically present in the courtroom.
Yes, Your Honor.
All right, very good. Mr. Schur, it is alleged that on April 4, 2022, that you did with the intent to kill or to do great bodily harm or to act in wanton and willful disregard of the likelihood that the natural tendency of said act would cause death or great bodily harm, kill and murder a Mr. Patrick Lyoya, and that the act was committed without premeditation or deliberation. That, if true, would constitute the felony offense of murder in the second degree. It is punishable by a maximum of life incarceration or any term of years. Do you understand the charge and the maximum penalty associated with the charge?
Yes, Your Honor.
And you had a chance to talk to one of your attorneys, Mr. Dodge, one of the other attorneys, about your rights?
As of today, I have not.
All right, have you reviewed the felony advice of rights form?
No.
Mr. Dodge, have you had a chance to talk to your client about his rights?
No, Your Honor, because of the issues here with where Mr. Schur is housed, we have not been provided those yet or had the opportunity. So it may be wise, Your Honor, to go ahead and review those
All
in
right.
court.
Very good. All right, Mr. Dodge, number one, you have the right to remain silent. You have the right to be presumed innocent until proven guilty. You have the right to a trial. And at the trial, you have the right, you have a number of procedural rights. You have the right to call witnesses to testify on your behalf. You have the right to cross-examine witnesses that are called against you. You have the right to ask the court to compel witnesses to come in and testify on your behalf. Are you familiar with the rights that you would have at a trial?
Yes, Your Honor.
All right. Very good. And Mr. Dodge, are you satisfied that your client understands his procedural rights at this point?
Yes, I do.
All right. Very good. Then I will advise everyone that the matter will be set for a probable cause conference that will take place on June 21, 2022 at 9:30 a.m. And if necessary, a preliminary examination will be held on June 28, 2022 at 1:30 p.m. The court notes the defendant's not guilty status. Finally, as to the matter of pretrial release, the court would first like to hear from court services.
Thank you, Your Honor. Article 1, Section 15, preventative detention does apply as the defendant is being charged with a capital offense. Therefore, the court may deny pretrial release. However, court services is not opposed to a cash or surety or a 10% bond, as there is no risk of flight, and in fact, Mr. Schur did self-surrender. There is also no prior criminal record. He is a lifelong resident of the Kent County area with strong, supportive family ties. There is no known history of substance abuse and also no known mental health issues. And there is a willing co-signer for bond if that were to be requested by the court, along with a stable release address that he also provided court services.
All
Thank you,
right.
Your Honor.
Thank you. Mr. Dodge, did you want to address pretrial release?
Thank you, Your Honor. I know the defense had an opportunity to file a motion for bond, which I understand the court had.
And the court has received that and did have an opportunity to review it.
Thank you, Your Honor. And we would also ask that the court follow the recommendation of court services here and set a reasonable bond. In this case, the defense would request, based on all the particulars that the court consider, a 10% bond. As noted, for assessment of bond purposes, Officer Schur is not a flight risk. He's a lifelong resident of Michigan. Other than some mission trips, he's He's resided in Michigan his entire life. No prior criminal charge or conviction history, very stable employment and family as noted. Your Honor, if there's any question as far as how Mr. Scher is going to behave in the next, while this case is pending, the court can simply look to the last 2 months since this episode arose, Your Honor, and that's been nothing but cooperation by Officer Scher and his attorney. So I strongly feel that there's not going to be any risk to the public, and there's no issue whatsoever of a flight risk. As noted, as soon as learning of these charges, Mr. Scher and his attorneys immediately coordinated. He's surrendering himself to these charges. Your Honor, the defense mentions a couple of generic facts in our bond motion, and I don't plan to get into any more facts today. We'll obviously get to those in future proceedings, but Your Honor, the defense submits that Officer Scher on this charge was justified in his use of force in this episode and is not guilty of this crime. And we ask that the court honor that presumption of innocence and set a reasonable bond here. So based on those factors, Your Honor, we would ask that the court consider setting a reasonable 10% bond.
All right, thank you, Mr. Dodge. Certainly the presumption of innocence follows along at all stages until there has been a plea of guilty or a finding that the defendant is guilty. Nonetheless, there is the question of what to do with a criminal defendant up until the time that a trial can take place, up until the time that the procedure can be carried out as far as determining whether indeed a defendant is guilty or not guilty. Those things are there to ensure that the defendant will be in compliance with court orders, that the defendant will appear when required. They are not punishments. The court does have to and can, to a certain degree, as long as it is reasonable, which is the constitutional standard, deny certain liberty to ensure that a defendant will appear in court. In Michigan, by Article 1, Section 15 of the Michigan Constitution, certain enumerated crimes, we should say it the other way, the right to bail generally exists. It can be withheld and a defendant held pre-trial without bail when they are charged with one or more of the enumerated offenses in Article 1, Section 15. The offense here is one of those. So the first question for the court is indeed whether the defendant is eligible to be released pre-trial at all, whether the defendant is bailable. Based on the factors here, particularly the fact that the defendant did surrender or turn himself in, has retained counsel, the defendant has no criminal history to speak of, the court can make the general finding that indeed the defendant at this point in time is bailable. And I will make that determination. The next question then becomes whether, or the terms and circumstances under which the defendant can be released. Our court rules require that the court generally presume a personal recognizance bond unless the court finds that a personal recognizance bond won't reasonably ensure the appearance of the defendant or that release on personal recognizance presents a danger to the public. Again, the court weighs heavily on the fact that the defendant did turn himself in. And at this point, there is no demonstration of non-compliance. However, the nature of a particular charge itself is another factor that the court considers. And there are certain charges, or capital offenses, that by the sheer nature that is the charge that the person is facing, elevates the risk, elevates pretrial risk. And I think the court does have to take that into account here. And so while certainly it weighs heavily on the court that the defendant has turned himself in, is in compliance, has no criminal history, those things weigh heavily, but the court also has to consider the charge. And so I don't think that a personal recognizance bond is appropriate under those circumstances. What I do find is that a cash surety bond is necessary, and I will set that bond amount $100,000 cash surety. That will also be subject to a number of special conditions that will be imposed as a condition of pretrial release. We'll order the defendant not purchase or possess any firearms or dangerous weapons while the case is pending. That defendant report to court services or remain under their supervision while the case is pending. That defendant not use any intoxicating liquors, marijuana, or illegal drugs. Undergo substance abuse assessment if that is directed by court services, if that is deemed necessary. And not engage in any assaultive, threatening, or intimidating behavior. Do you understand all those requirements, Mr. Scher?
Yes, Your Honor.
All right. Mr. Dodge, anything further from your perspective?
No, Your Honor, thank you very much.
All right. All right, good luck with everything. And again, before the record, and so everyone has it down, the probable cause conference will take place on June 21, 2022 at 9:30 a.m. and preliminary examination, if necessary, will be conducted June 28, 2022 at 1:30 p.m. All right, take care, everyone. Thank you.
Thank you very much.